14,250 divided by 30, multiply it by 15, multiply it by the number of years of service. So your calculation for purposes of layoff, retrenchment, closure compensation is going to come down because of this definition of wages. Similarly, let's go to the second scenario of where the total salary is 20,000 in this column that is there to your left. Here again, you will be now taking only 12,000 as wages, not 20,000. Earlier, you would have taken 20,000. So now you will take only 12,000 as wages, and on that 12,000, you will compute for retrenchment compensation, closure compensation, etc. In this first case, it will be 12,000. There won't be any change. Similarly, PF, ESI, all these you are going to now take the first case 12,000 here, 12,000 in the second case as well. And in comes to the third case, you will take 14,250 and on that you will pay PF and ESI. But of course, I should also point out that because of the judgment, if you hiked up your PF and you're today paying it on the entire 28,500 or on the ceiling limit of 15,000, you may not be able to reduce it to 14,250. You need to continue with what you're paying, at least up to the ceiling limit of 15,000 you may need to pay. So this wage definition, though they have tried to bring in uniformity, it is going to have an impact. So on code on wages, minimum wages, bonus, it's going to have a different impact. In the social security, when it comes to ESI, PF, gratuity, it's going to have a different impact. When it comes to OSH on OT, it's going to have a different impact. So the definition is the same. So based on that, if you look at it, it is going to have different impacts, positive and negative impacts for employers. Similarly, now this code, to whom does it apply? Does it apply to a factory? Does it apply to a shop and commercial establishment? That is going to be again an issue that you would need to see because it is not uniform. For instance, if you look at the IR code, see, I'm showing you the definition of industry under the 1947 Act. Everything was brought within the definition of industry as far as the ID Act was concerned. This is the definition in ID Act. Then they wanted to amend it in 1982 and they wanted these 9 activities to be excluded from definition of industry. So hospital dispensaries will go out, education will go out, charity will go out, khadi will go out of ID Act. This is the idea that they brought in 82. This was never implemented. Ultimately, today what we get in the IR code is a definition. What they're primarily now excluding is charitable, social, and philanthropic service. All these 3 will get excluded from the definition of industry, and therefore the IR code will not apply to any charitable, social, or philanthropic service, whereas till date it was applicable, but now it will not be applicable. Now I will going to dig more into IR code because the changes in IR code is significant and it will impact most of you, I think, are from manufacturing as well. So the impact on IR code is significant. So I will be spending a considerable time with IR code. As rightly pointed out, in 1 hour's time, I may not be able to do justice in all the codes. So I am trying more to concentrate on IR code and I would like to take, because I would like to take questions. So I will try as fast as I can to complete the other codes as well. The term employee has been defined, but it doesn't make any, because the term employee is defined in all the codes. And why I am pointing it out here is supervisory, managerial, administrative people are all brought within the definition of employee. Where this employee definition becomes crucial is more under the occupational safety health code. In OSH code, they use the term worker when it comes to factory. So if you look at it, overtime wages is no longer available to your clerical staff and everybody because it's restricted to only workers under the OSH code. So if you look at within the OSH code, some places they use the word worker, some places they use the word employee. If it is employee, it is all the more comprehensive. Even yourself would come within the definition of employee. So even your managerial people, HR, everybody will come within definition of employee. So you need to carefully see whether the word used is employee or worker. The same definition is there in all the codes. The employer definition is very particularly in this IR code alone is quite significant because earlier it used to bring everybody. So it could be a HR manager, it could be your vice president, it could be your general manager. They could prosecute anybody. They can file a complaint under Section 29 against anybody. But now they are restricting it only to a occupier of the factory. Of course, occupier is also going to be a director of your company, but then we know that it is only this one person can be there. And one inclusion here in the third one is the term contractor. So contractor is also an employer. So this, I don't know, every contractor is also an employer. Why they should specifically put it down here, we don't know, but they have done it. The worker definition, again, nothing much, no major change, except that because they are bringing the Working Journalist Act and the Sales Promotion Act also into this, they have brought it in. And also section in the disputes part of the IR code, we had section 2A, which allowed individual employees to raise disputes. That is, people who are dismissed, discharged, retrenched, they could also raise dispute. Now, they are also brought within the definition. So even a dismissed, discharged, or retrenched workman will continue to be a worker so that he can raise a dispute. Therefore, that is the only change in worker definition. And they have raised the ceiling to 18,000. So your supervisors up to 18,000 will also be workmen. That's the definition of worker. Appropriate government, again, it's only because they use the word contractors in this. That is the only major change in the appropriate government. Given the paucity of time, I'm not going into detail because most of you may be from private sector and it's actually going to be the same. State government will continue to be the appropriate government for you. Fixed term employment, this has been brought in here, and it is even in the Social Security Code. So now you can start to engage fixed term employees. I know many of you want to know how many persons you can engage, how long you can engage, can you keep on engaging them after one after the other. So if it is 5 years, then another 5 years, another 5 years. All these things are not clear today. We need to wait for rules. As far as fixed term employment is concerned, these are the simple things which is already there in most states. Of course, Tamil Nadu did not have it, but Gujarat, Rajasthan already had fixed term employment, and the government had already brought it in apparel industry, and as well as wherever the central government had introduced this, state governments had not in some places. Now they are introducing fixed term employment. We need to wait and see how they are going to position this fixed term employment. How many people you can have? Is it going to be a proportion to your permanent workmen, and etc.? We need to wait and watch. Industrial dispute, again, not much change in the definition. Therefore, I won't trouble you. Retrenchment, the only change that they have brought in retrenchment is that the fixed term employment, when it comes to an end, will not amount to retrenchment. That's the only change that they have brought in here in respect of retrenchment. Strike, you will find this last portion. There is a change. So if you have 100 workmen and if 55 workmen apply for a casual leave, then even that is strike. So that portion alone has been now included. I will not trouble you with all these definitions. One major change, see, except for Maharashtra, recognition of trade union was not compulsory anywhere. But now across the country, recognition of trade union is going to become compulsory. So if you have 100 workmen and if 51 workmen join one union, 51 or more workmen join one union, then you don't have a choice but to recognize that union as a negotiating union, and you would need to negotiate with that union. So 51%, yes, well and good. If you don't have 51%, let us assume 30, 30, and one has got 40, then they're going to proportionately, they would be sending representatives, maybe like 3, 3, and 4, and you would be required to form this negotiating council, and with them you would need to negotiate. So no more of saying, oh, this union has got, I will not recognize this union, I don't want to talk to this union. So these changes are going to come. So 51%, you don't have a choice but to negotiate. Less than 51%, it is going to be a council with which you will be negotiating. Standing orders is concerned, 300 plus workers, then you need to have your, you don't have to have a certified standing orders. Only if more than 300, you need to have. So smaller factories don't need to have their certified standing orders. What happens to my existing certified standing orders? Once the code is notified, it becomes null and void. That standing orders will have no force once the code is notified. Am I audible? Because
yes, sir. Yes, sir.
Yeah. Yes.
Thank you. So that is the change in standing orders. The other aspect is, even if you have 300 or more workers, let's assume your factory has 500 workers, the state government will publish a model standing order. So if the government publishes a model standing order and you don't want any change to it, all you need to do is send a letter to the labor officer saying, I am adopting the model standing orders. It is not that you have to go and get it certified. You don't need to. So automatic application of a model standing orders. No more certification is not mandatory. Certification only if you want a change. Similarly, for retrenchment under Chapter 5B, the limit has been enhanced to 300 persons. So if you want to retrench, layoff, closure, so only if you have 300 or more workmen, then you need to go seek the permission of the government. If you have less than 300, then you don't need to seek permission of the government. You can straight away retrench, layoff, or closure. But of course, you need to follow FILO, LIFO, compensations, notice pay, etc. All that remains the same, no change. But as I explained to you when I was dealing with the wages definition, because of that definition, your retrenchment compensation is going to get reduced substantially. Some places it could go even up to 50% down because you'll take only 50%. So it's going to reduce substantially. Today, you know, when a union raises a dispute, that dispute goes to conciliation. Then the conciliation officer will give a failure report. After that, the failure report goes to the government. The government then refers a dispute. So government will say, this is the dispute between so-and-so management and so-and-so union. I am referring these disputes for adjudication. You adjudicate and tell me, and it will go to tribunal or labor court, depending on the number of workmen. Now, no more reference. So in union or individual worker, in case of dismissal retrenchment, they'll go to the conciliation officer, give a petition. If you reply, well and good. If you don't reply, if no settlement is happening, on 45th day, they can go to the tribunal straight. They don't need to wait for failure report or reference, nothing. Straight they can go and file it. And the word labor court has been completely deleted out. There is only industrial tribunal. So because there was a tendency to say that if it is labor court, then it has to be labor friendly. So now they have deleted it. So it is only industrial tribunal. So the industrial tribunal will adjudicate once the petition is filed. And it also has the power to grant interim relief. So your workers give you a charter of demand. You try to talk to them, nothing happens. They will go to the conciliation officer. 45 days from thereafter, they'll simply go and file a dispute. And the worst part of it is they can also ask for interim relief. So even, okay, I have asked for a wage increase of 10,000 rupees, but my family is starving. So ask them to give me 2,000 rupees interim relief for now. So tribunal has been granted the power. It was available already, but this is being made more explicit now. So it is going to be challenging. Even a dismissed employee can file an application for interim relief. And that is the kind of power that has been given to the tribunal. And the tribunals are going to have two judges instead of one. One judicial and one administrative member would be available. So two of them has to hear. And so every tribunal, so if you have your labor court in Hosur, that is now going to be termed as industrial tribunal, and it will have two judges instead of one judge. I gave you some bad news, so let me give you some good news. Strikes. See, till now, what was happening with the strikes is there was something called as public utility service and non-public utility service. So in public utility, it's very difficult to go on a legal strike. So they will go on strike. I'm not saying workmen don't go on strike in public utility, but the strike will be illegal. So you can do a wage cut, you can do treat them as loss of pay, 8-day wage cut, all those things you could do. But in non-public utility, they can just like that randomly go on a strike, and you may not be able to do much about it. But now, what the law has done is they have to give you 14 days, irrespective of whether there's no more public or non-public. In every industrial establishment, the workmen should give prior notice. And once they give a notice and you take it to conciliation, during that period, they can't go on a strike. Therefore, strikes, that to a legal strike, is going to be challenging for the workmen. It may not happen. A legal strike is not going to happen once the IR code comes into play. It is more likely to be an illegal strike, no more legal strikes. A new concept called the Grievance Redressal Committee has been brought in. The purpose is to ensure that inside both the employee representatives will be able to sit together, talk, and bring about a resolution. So there could be 5 people from management side, 5 people from the workmen, 10 of them sit together. So anybody has any complaint, they'll give it to that committee. The committee will try to resolve the grievance. So it could be individual, it could be a group of workmen. So that could be, and if there are women employees, they should also be part of this committee. There's also one more protection. It is not a majority decision. So let us assume 5 workmen, 5 management. And even if one worker votes, so it is 6 against 4. No, it is not like that. What happens is out of the 5 workmen, 3 workmen should agree to whatever consensus you arrive at or a solution you arrive at for the grievance. Only then it is enforceable. Otherwise, it's not enforceable and can go to the conciliation officer within that. So that is the manner in which this has been done. But again, it's all time bound. So within 2 years, if they don't raise a dispute, then the dispute becomes barred by limitation. So if a worker is dismissed and for 2 years he doesn't raise a dispute, it is barred by limitation. If there is something that as a management you have done, the union doesn't raise a dispute for 2 years, then it is barred by limitation. So that is one good thing that has come about in this new code. Unfair labor practice continues to be the same. The only new thing about this code is this reskilling fund. So if you return somebody, you will need to pay 15 days salary to this reskilling fund. Not every year. It is only 115 days salary alone you would need to pay. So if you're retrenching somebody with 10,000 rupees wages, you need to pay 5,000 rupees to the skilling fund. Again, what they're going to do with the skilling fund, etc., we need to wait for the rules to understand what is going to happen. No more. In most of the codes, in all the codes, they are trying to do away with imprisonment of employers. It will all be fines. So that is going to be a substantially good aspect. You know, today, earlier days at least, you know, you could just go to the court, pay the 500 rupees, 1,500 rupees fine and come back. Today with computers, what is happening is all these fines that you pay are getting recorded. So please be aware. So when a background verification check is done, in fact, yesterday I had a case where 4 years ago, one employee was there. He went in his capacity as whatever manager or so. He paid the penalty. That is now captured. So with his new employer, when he went and it comes about, the background verification says there is a criminal record, And that criminal record is because under Contract Labor Act, they didn't maintain a form for that. But now with this, you can just go to the authority, pay the fine, it won't go to court. And the fine amount will only be 50% of the total. Therefore, it will not record anywhere in your criminal records. So that is the kind of the compounding that has been brought about in all across all the codes in most cases, except for a few cases. In most cases, it is going to be only compounding offenses. Moving on to Code on Social Security, it covers a whole host of things. No major change in PF, ESA, or gratuity or maternity benefit. What does this, apart from the normal workers, they have looked at gig workers, platform workers, and unorganized workers. So gig workers is your Swiggies and Olas, and all these people are gig workers. Platform workers is somebody like your Urban Clap. So they are where you come and provide a service, like a beautician coming to you or a carpenter coming to you, something like that. And unorganized workers is the rest where they are brought in. So these people, for these people, they're going to frame a separate scheme. So for any one of them, it could be one scheme for gig workers, one for platform, or it could be a combined one. So now this act provides the government can frame the scheme. That is one new addition that the Social Security Code brings in. And in most of the codes, the term contractor is also including interstate migrant worker. Contract employee includes interstate migrant worker also. That is a new change that they are bringing about. The ESA part of it, employment exchange, is now going to be called as career centers, and from there you'll be able to see vacancies. As a private employer, you may also need to inform the career centers of any kind of vacancy that may arise in your establishment. But of course, we have to wait for the rules in this aspect. The central government is given the power because of this COVID. This is the only thing which reflects the COVID, nothing else. Because of COVID, if was any change brought about for work from home or anything, if you ask me, no. The only change that you will find is government can reduce or waive off payment of for ESA. Aadhaar registration, Supreme Court has said you can't make it mandatory, but the code again makes it mandatory for registration of Aadhaar. If you want to challenge any order passed under this code, PF, ESA, or whatever, you have to deposit 25% of the amount. ESA already had a limitation period of 5 years. Now the same 5-year period is being brought in across this code as well. So even PF, they can't go and ask for beyond 5 years. That's a changes in, as I said, my primary focus was only in IR code. These two codes, I haven't touching it much because especially this code, if you look at except the Factories Act and contract labor, others all is industry specific. So the factory threshold is increased to 20 with aid of power and 40 without the aid of power. Every establishment should have a license and register itself. I am not talking of contract labor license. This is under the separate license just to register yourself as an employer under the OSH code. Every employee should be given an appointment letter. So if it is a contract employee, you should ensure the contractor gives. If he is your employee, you should give an appointment letter. So he could be a fixed term employee, he could be a permanent employee, or he could just be a daily casual labor. You have to give an appointment letter. Therefore, appointment letter is becoming mandatory under the new code. You can't ask employees to work overtime without their consent. So you need to take prior consent. So when you next time draft a settlement, you just wise of you to include a clause saying that workmen consent to work overtime. And every end of the calendar year itself, if they want, the workmen can encash the leaves which exceeds up to 30 days, they can encash it. Contract labor, as a principal employer, you have to register and the contractor had to take license. Now that is gone. No more. It is only the contractor alone who needs to take a license. Principal employer doesn't need to register. That's what at least the Act says. I don't know if they can bring any rules contrary to it. But at the moment, as things stand, it's only license, no more registration. And even that the contractor needs to take only if more than 50% are deputed by him to work in an establishment. And the validity of the license will be for a period up to 5 years. So it could, if you say 5 years, it will be 5 years. If you want it for a lesser period, it could be for a lesser period. Women workers can be employed after 7 p.m. but before 6 a.m. subject to them agreeing. They should give a consent. So if woman workman gives a consent, you can employ her in the night shift. And of course, there are going to be rules for that. And this is now across establishments. So it is not only factory, it could be anywhere, any place to which this OSH code applies. This could, because the term in OSH code includes even commercial establishments. So any place where industry, trade, or business is carried on. So your offices, so your BPOs, IT, ITES, everything could come within the OSH code. It is no more the Shops Act alone. As far as the interstate migrant workers are concerned, the only thing is that you need to pay for that. Once a year, they should go to and fro, and for that you need to pay. And the definition of interstate migrant is very different. Earlier, only if a contractor goes, let's assume he's from Assam, contractor has to go to Assam, pick him up from Assam, bring him here and give you employment, then he'll become an interstate migrant. But now if an Assamese person comes to Hosur and takes up employment in Hosur, then he is an interstate migrant worker. You would need to cover him under the new code. Sorry. Yeah, these are all not of much significance. Offenses and penalties have been increased substantially into lakhs from thousands in most of these codes. So even if you compound and pay 50%, it's going to be a substantial amount like 50,000 or 1 lakh. So that is going to be. And the inspectors are being called as facilitators. So they can come and first warn you, say what is wrong with you, and it's not that they have to straight away prosecute you or impose you with a punishment. So as I said, these are all more. I've tried my best. I've kept it at the least. I've given you only a bird's eye view, and I'll be glad to answer a few questions if time permits.
Sure, sir. Thank you. We do have a bunch of questions which have come up in the chat box. I will ask them for you. So the first one that we have received is, so once these codes are applicable across the country, what happens to the state acts?
Most of them didn't have a state act. No, certain state acts will continue. So state acts don't get repealed. It's only the central acts are getting repealed. So, but if you look at minimum wages, ID, and all these are all central enactments. But where you have your Tamil Nadu Conferment of Permanent Status Act, Tamil Nadu Subsistence Allowance Act, Tamil Nadu Shops and Establishments Act, Tamil Nadu Holidays, National Festival Holidays, all these will continue. Therefore, there will not be any change in the Tamil Nadu enactments. But where there is repugnancy between the two things, so if your Shops Act is there and your OSH code is also going to apply. So OSH code is not only to factories. OSH code will apply even to shops and commercial establishments. So what the governments are going to do with that, we need to see. And if there is a repugnancy, it will be the new law that will apply, not the old law. So that we need to wait and see. As I said, these are all some gray areas which we need to slowly try to iron out.
Sure. Thank you, sir. So before I ask the next question, a request to all the participants that you can please post your questions in the chat box so that I can ask a speaker. Sir, going in for the next question. So there is a question where they're asking, can there be a scenario where fixed term employee can join union?
Yes, he can join union, but there's nothing much he can do out of it because his term is fixed. End of the term, he can go. And what the wages for the term, you would already fixed. So yes, he can join the union, but it may not help him in any manner is my, I mean, of course, subject to what rules come, but it is not going to be helpful to him. So your worst liability is, so if you take somebody for 5 years, on the end of it, it comes to him. So if you terminate him in the third year for any reason, so he's done a misconduct, you're throwing him out in the third year, your liability at the worst case would only be to the fifth year. So 2 more years of salary he will get without working. That's your worst liability. So joining the union is not going to help him in any big manner. Therefore, the chances of them joining is also very remote.
Sure. Thank you, sir. That definitely helps. So moving on to the next question. So this is relating to the standing order. So I'll club two questions and I'll ask you. So the question asked here is, can a factory with less than 300 employees have a standing order? And if they're having less than 300 and they still want to get the certified standing orders for the establishment, will the authority allow it?
The act doesn't talk about it, to be very honest, what happens with less than 300, but you could always go. Yes, we less than 300, you can still, you don't need a certification, but you can have your own standing orders. Even if you're less than 300, you don't need a statute. Statute says 300 compulsory. Below that, if you want it, it's your option. It should be possible.
Sure. Thank you, sir. The next question is how to decide the majority union for recognition and what is the process to be adopted?
That the rules have to come for it. How long? Every year you need to conduct the union this exercise, or once in 3 years you need to do, once in 5 years you need to do. All these things, we have to wait for the rules to come. They will definitely lay down as to how to arrive at it.
Sure. Thank you, sir. So going back to the same 300 number, so one of our senior member asks, for retrenchment or layoff, the strength of 300 workmen would also include the contract laborers, management staff, etc., or would it only be for workmen?
No, this will only be workers. So if you have 300 workers, that is when the permission is required. So your others, contract labor, management staff don't need to be taken. Management staff will need to be taken if they answer to the definition of worker. You could call them staff, but if they're doing only clerical work. See, many of you may think, oh, pilot, he's a great guy. But what is a pilot? Pilot is nothing more than a driver. So just like how a bus transports you from Hosur to Chennai, only thing pilot is trying to fly a plane. Other than that, he does the same job as a driver. So he's also a workman. Similarly, many of the software people, he could be getting 2 lakhs, 3 lakhs writing a code. He should be a good programmer, he may get, but he's also only a worker. So there are many places where they think, okay, he's sitting in the office, he's not in the factory. Therefore, he's a staff. He's a staff, but he's also a worker. So therefore, management people who are really doing managerial work, you can exclude them. But if managerial people who are doing only clerical work or just a worker definition, if they come in, you need to include. But contract labor doesn't need to be included.
Sure. Thank you, sir. Moving on to the next question. This is on the committees that the codes are talking about. How is a works committee different from the redressal, grievance redressal committee that is already there?
I don't know how it is different, but then they are asked you to do both. So works committee is also continuing with the IR code, but the new GRC is also going to continue. So GRC is more mandatory, but works committee wasn't mandatory. It wasn't given much teeth to do anything. Now here they can come to any kind of conclusion, and that conclusion gets a binding effect. So if out of 10 persons, 8 of them come to a conclusion. So you dismiss somebody from work, for instance. And then management says, or you all discuss, 5 management persons, 5 workmen representatives sit and discuss, okay, he's done a misconduct. We think dismissal is justified, but okay, we will pay 2 lakhs compensation. If that is the conclusion you come, and 8 of you agree to it. So that will be the resolution by this committee saying, okay, we will throw him out, but throw him out with 2 lakhs. So then, of course, it is for him to accept it or not accept it, but it will have some binding value when he goes to the court. So to that effect, GRCs are going to be different from your WCs.
Thank you, sir. So the next question, there's been a lot of speculation on this about the eligibility criteria for the gratuity or the eligibility period for gratuity. Is there any changes that has been changed from 5 years to 1 year?
No, 5 years is still there. Your permanent employees, it will be 5 years. Your fixed term employees, if they work even for 1 year, they'll get 1 year gratuity. If they work for 2 years, they'll get 2 years gratuity. The reduction as such has not happened anywhere. I mean, for working journalists, it was already 3 years under the Working Journalist Act. That is again been brought in here because that act is also getting merged. But apart from it, there is no reduction in the period of gratuity, it's same 5 years.
Thank you, sir. So the next question is, so I'll probably club a couple of questions here. So is breaking the minimum wage applicable for regular staff, and is performance bonus part of the salary if it is paid monthly?
See, till now, you could have broken minimum wages. As I said, 12,000 could have been broken into 4,000 basic, 4,000 DA, 4,000 HRA. Going forward, for nobody you can break. Not only your permanent or contract, nobody you can break. If government gives 6,000 basic, 6,000 DA, you have to pay it as 6,000 basic and 6,000 DA. No more splitting of it. Maybe you can call it 12,000 as basic and you don't have DA, fine, that is permissible. But you cannot have a HRA within it. If you do that, you won't be complained. Therefore, that is gone. As far as bonus is concerned, performance bonus, it may not come within the definition unless it is more than 50%. So if your salary is, let us assume 20,000 rupees, and your performance bonus is going to be 12,000 rupees of that, then to the extent of 2,000 rupees, it will become answering to the definition of salary. So because 8,000 plus 2,000, 50%. So from 20,000, 50% will come, then it will get answered. Otherwise, performance bonus and all, it goes out of the definition of wages.
Thank you, sir. So the next question, again from one of our senior members. So this is being checked whether mines are covered under ESI, under the CSS code 2020.
It looks like it because it is the term establishment, and so looks like it as of now that they are planning to cover it because the term used is establishment and mines is the included in the word definition of establishment. So they do propose, I think, to cover it, but it is too early. See, some places we don't know if it is by mistake they've brought it in, but as on date, yes, mines also could come within ESI.
Thank you, sir. So another question is asked that in case an organization has majority of fixed term employees and a few full-time employees, won't the union formed by fixed term employees make a difference?
I'm not sure if the law is going to permit you, first of all, to have majority of full-time or not. So that itself is questionable. We don't know. So maybe the law will say if you have 80 permanent workmen, you can have 20 fixed term or something like that. It is not going to allow you to have 80 fixed term and 20 permanent. One aspect. Second, it doesn't make a difference in my, even if you're allowed to have 80, I don't see how it is, because when you take somebody for 5 years, you tell him what his salary is going to be for 5 years. So first year you will get 10,000, that will become 11,000, 12,000, 13,000, 14,000, 15,000. On the end of the 5th year, tata, bye-bye, see you. So it is over with that. So therefore, it doesn't make much of a difference is my view on that.
Sure. Thank you, sir. So the next question is, they're checking, as per the new code, what kind of new empowerment is provided to the employer to control any unauthorized strikes?
See, the thing is, all strikes are made illegal. That is the fundamental. So strikes could be legal, strikes could be illegal. For instance, then it has to go for adjudication and things. And then becomes, there are 4 types of strikes: justified strikes, unjustified, legal, illegal. So this is the broader classification in which strikes were coming. But now, going by this new law, all strikes are more likely to be illegal strikes. So once it is an illegal strike, you don't need to pay wages for that time. Second, you can also do an 8-day wage cut. You get the power to do both. So to that extent, it has empowered you.
Thank you, sir. Once these acts are published in the Gazette, so we assume that the pay structure will change in the organizations. Do you see any impact other than in-hand salary for the employees, hoping that the CTC shall remain the same?
CTC will remain the same. It is not that it's going to have much impact. Most of your establishments may not get impacted, where the impact is going to be only in contract labor. So in other establishments, I don't see much of a change happening, except that, see, there is no scope to do a change here now at this moment. Anyway, you have to do on 50%, you have to pay gratuity, 50% you may need to do on other things. So pay structure at the lower end is what is going to change, not at the higher end. So, yeah, and especially in organized industries, it is not going to be. Where you have a manpower contract only for, where you pay only contract labor, only the minimum wages, those are the places where you will have these changes.
Sure, sir. So the next question is, if the Occupation Safety and Health Code comes into force, what is the validity of our factory's license?
It could be up to 5 years. Starting from 1 year to 5 years. Again, we need to see the rules where, and if Tamil Nadu government, what rules Tamil Nadu government comes. So central government can come with its rules. Then after that, Tamil Nadu government could come with different set of rules. So we need to wait and see what happens there.
All right, sir. Thank you. So the next question is there a difference between temporary workman and fixed term employee? So this is a question.
Fixed term is, you have to take him into employment, let's assume 3 years. Then you're going to pay him for 3 years. You're going to keep him on rolls for 3 years. Whereas the temporary workman is, when you need, you may call him for work. So one day you will call him, second day, so somebody absents today. So you call a person, he will work for you. And that person comes back, your employee comes back, you want to engage him. That is your temporary workforce. So that is not going to be, that is going to continue. The difference between fixed term and this is, on a fixed term, you will be paying him salary for days he is willing to come to work. So if you keep him for 3 years, and if he comes to work on all 3 years, you have to pay him work for all 3 years, every day in those 3 years. Whereas in a temporary, you will be keeping them only, okay, I need you only for 10 days. You came for 10 days, I'll pay you 10 days and it will be done with that.
Sure. So, and what is the possibility that I convert this fixed term employee into a full-time employee?
Fixed term into a full-time, yes, you can do at any point of time. But most of you will want to do the other way around. You will want to convert your full-time to fixed term employment. I don't think that is going to be possible.
So the next question is, what happens to the Employees Compensation Act? So will the conditions remain the same or will they change?
Yes, there is no change in the EC Act. There's no change at all. Okay,
sir. So probably we'll look at one last question. So this is a question that comes from Mr. Bharatraj Singh. So this, so what are the critical things an organization should immediately work on once these acts are published in the Gazette? So what is the checklist that needs to be put in from an organization once these things are officially on Gazette?
I am not sure. Your minimum wages is something that you may need to work. But then if you're not registered under anywhere, you may need to register. I'm not talking of Factories Act, but the government is going to bring a portal for registration. These are the two things that immediately comes into my mind. But it's a good question. Let me think and I'll try to share what may be need to done. If appointment orders are not being provided, you need to issue appointment orders wherever you're not issued appointment orders. But apart from it, on a complaints part, what you need to do immediately may not be minimal. It's only the minimum wages and issue of appointment orders.
One last question from my side. This wage code, what is the current status? Having passed very long back, we are still waiting.
Yeah, we are still waiting. They want to announce all the 4 codes on one day. It will be one notification. All 4 codes will come sometime in December. All 4 codes are going to come.
Okay. Thank you. Yeah, over to Bonish.
Thank you, sir. So that was a very enlightening session. So we did have a lot of queries, a lot of speculations that were floating around being cleared through this session. Thank you for that, sir. I request Mr. Ravichandran, AGM HR of Shukla and Hosur, to please deliver the vote of thanks for the session.
Thank you, Bhunesh. So this is actually a eye-opening session to all the HR fraternity. Advocate Anand Gopalan from TS Gopalan and Company has shared, many things which are very relevant and important at this point in time. Though the session name is Decoding the Labor Code 2020, he has covered largely on the Code of Wages 2019, IR Code 2020, Social Security Code, as well as OHS WC. So while you're talking on the IR code, it started with the wage definition and moving on to who is employee, worker, and then employer. What is fixed term all about as per the code? Then what industrial dispute talks about in the new code? Then the changes in the retrenchment and what is strike, and then the trade union impacts. Then also the standing order applicability, retrenchments, the importance of tribunal, then of course the condition of strike, then what is redressal committee, what is the difference between the works committee, then also covered on the social safety benefits, and then the importance of appointment letter, the overtime, the contract labor, and then the relating to license. How about the treatment of women worker? I think what more, including the interstate migrant workers, etc. So I think covered, quite a lot to get. I think a lot of things we have in our mind and we need to move on. So at this point in time, we sincerely thank NHRD Hosur chapter for organizing such a mega events continuously month on month and during all COVID period. And lot of engagement from NHRD Hosur chapter, not only for the chapter members, and I think Pan India getting benefited out of this. I sincerely thank the President NHRD, Senior GM of Fowler Westrup, Mr. P. Murthy, who is taking all initiatives and making the session very nicely done for all of us. And we sincerely thank all the NHRD members, particularly the ECMs, and they are taking much effort in, conducting more such programs. Not the last and the least, and then the HR fraternity, the members attended the session very well and posed a lot of questions. I think for the rest of the questions, I request President President NHRD to take those questions and then we can give a response to them. Thank you one and all for the nice listening and then making the session like important one for each and every one of us. Thanks once again on NHRD Hosur chapter. Thank the Advocate Anand Gopalan very much, sir. Thank you very much.
Thank you.
Thank you, sir. Thank you very much.
Thank you.
Yeah.
Thank you.
Thank you, Anand, sir. Thank you, everyone. For those
Thank
of
you,
you who
everyone.
joined from across the length and breadth of India, I
Sure.
hope you have a very good night and stay safe wherever you are. We'll catch you up in another program of ours. Thanks, everyone. Take care.
Thank you, Bhunesh. Thank you.
Thank you, sir.
Thank you, sir. Thank you.